Peter, if I could turn to you and your more expertise around Delaware law and ask you to really tell us about the evolution of Caremark and how that may or may not have impacted boards and where we are at Caremark, or you think boards really understand their Caremark duty, at least around anti-corruption compliance.
I think starting with Caremark, which itself built on, I think, Alice Chambers, but that decision was a settlement actually handled by our old friend and partner, Joe Linklater, in part. And the court's pronouncements in there really kind of built the two-prong claim. I mean, one was for information systems, which looks to, did you utterly fail to implement, any reporting or information controls? And the second being red flags, which is were you knowledgeable of information so that what you were no longer entitled to rely on the assumption that the company's employees are acting with integrity. And as you build forth from there, I mean, there are many cases for many years that said this is the hardest claim for a plaintiff to make. But the obligation, I think, the kernel of truth, and in that case, in Caremark, it actually looked to the then federal sentencing guidelines and the incentives created there to have a compliance program, which benefit the company in terms of credit, time of sentencing, to really build forth what was a duty of oversight, but again, to have some sort of reporting system and information controls. Fast forward, I think it was a lot of, I'll call kind of event-driven filings saying the board failed its oversight because of something happened. But now fast forward more recently, there started to be more cases where it seemed, and again, these were motions to dismiss as opposed to merits trials or after the fact judgments, but plaintiffs were beating motions to dismiss in a couple cases, bringing forth a question, is the standard becoming more relaxed? And I think the more recent cases have made clear that no, it's still an incredibly difficult standard for plaintiffs to meet, but it does inform, and I think those cases inform how boards approach compliance, what their duties are, what are the mission critical risks, I think as the court rightly framed it, that boards focus on. It's not every single risk in the world that the board must exercise their oversight over, but looking at those mission critical risks and in most recent cases, really looking at legal risks, compliance risks, as opposed to business risks, which tie back to some of the Delaware Supreme Court jurisprudence in this area as well. So I think, Tom, it does inform directors. It serves as a backstop as to why you have these programs. I think also on the red flags claims, if you're a director and you start hearing information that suggests, again, that you have reasons to believe that laws are being violated, you certainly need to attend to them. I would assume most directors in their, frankly, good judgment and their good business acumen would do that as well. They're not there to break laws. One Delaware then vice chancellor and then eventually chief judge of the Supreme Court wrote, Delaware doesn't charter lawbreakers. But I think at bottom, there was an initial for many years kind of status quo with these claims with a little bit of a dip where people suddenly became concerned that the standards were becoming more pro-plaintiff, pro-stockholder, but more recently confirmed again that the standard is held well. It didn't open the floodgates, to claims by disgruntled stockholders, but again, it reminds boards to focus on those mission critical risks.
I might add that in this area of dealing with directors, you can talk about Caremark, and it's very important for them to understand the legal principles there. But one of the things that I've done that I find very effective is Walmart was a massive case involving Mexico and licenses down there. And a reporter with the New York Times by the name of David Barstow wrote a blockbuster article, and I have handed that article out to directors and said, read this if you want to understand what can unravel in the FCPA space. And they may not understand a legal opinion reading it, but they read that New York Times article and they understand what a massive headache a corporation, and of course, every director is familiar with Walmart and their basic business model. That's something that I've done with success.
Let me change the focus just a little bit and ask, what are some of the key strategies for conducting and defending an FCPA investigation circa 2024?
In the book, I have a chapter, I think it's chapter 2, where I go through every FCPA defense that's available. And a lot of the defenses are the same ones you have for any white-collar criminal case, which is the quality of the evidence beyond a reasonable doubt. What are their witnesses like? What sort of deals have they handed out? But then there are some that are kind of unique. Recently, there was a case in the Eastern District of New York, Aguilar, where it involved Pemex in Mexico, and the defendants allegedly had given things of value to employees of Pemex, and the court analyzed the evidence and said these are not government officials. So you do have these sort of one-off defenses in this area. You have sometimes foreign bank accounts the government's not able to get. I think they're having more success because there's much more international cooperation. I'd say in the last 10 years, the quality and quantity of international cooperation has improved tenfold. And you're seeing South Africa now. There have been 2 FCPA cases for the first time coordinated with the South African authorities. And you look at the big, like the last 4 FCPA cases, which you've got, let me see, if you've got Glencore, Goldman Sachs, and Goldman Sachs is mandatory rating material. In chapter 10, I outlined the evidence for all 4 of these cases, and I think that's helpful if you want to analyze how the government puts a case together. You read those 6 cases that I have in there, and the Goldman Sachs one is just stunning because, I mean, one of the preeminent financial organizations in the world, from what I can tell, had no internal controls. The head of Southeast Asia was in charge of this incredible corruption scheme, and the trial of Roger Ng, that's NG, was held in New York, and I was able to read and follow that trial very carefully, and I'm still sort of in shock. And to this day, we see household names still being charged with FCPA. Of course, every case is unique. You've got to sit down, and you'll have clients say, what do you think? Until you look at those documents. And I think that's another area that has really changed is the forensic accounting and forensic research that goes into these. There are thousands and tens of thousands of documents that have to be screened. Sometimes you get exculpatory material in those document searches, but obviously you're looking primarily for the inculpatory and how to deal with that.
So from there, Bob, what are some of the maybe trials you looked at? Because we've had a few, and you mentioned specifically Roger Hung, but what are some of the lessons that we as compliance professionals or counsel may take away from these trials?
I can't argue with the success of the DOJ in the 6 trials, although one of the cases, which was the Boston case with Bonsi and Baptiste, was thrown out afterwards because of a discovery violation. The FBI had not turned over a tape recording that the defense said was exculpatory, and the judge in Boston, after the U.S. attorney moved to dismissed that whole case. And there was also in the Ng case in New York, there was like 15,000 plus documents turned over in the middle of the trial that the defense had received. So one of the things that I really encourage, and I've been a big advocate of Brady versus Maryland rules for decades. I wrote a American College of Trial Lawyers proposal on Brady versus Maryland, which is most of your audience will know is the duty to turn over exculpatory evidence to the defense. And the problem with, I think, that is too often lawyers will just make a generic return. Please turn over any and all exculpatory evidence. And frequently the government will respond, we don't know what your theory is, so we don't know what exculpatory is. And some of the agents, the law enforcement agents, have no idea what the obligation is under Brady or what exculpatory evidence is. And so I think it's really incumbent upon defense lawyers to put in a detailed Brady motion very much at the outset. And in one of these 4 trials, it kicked out all of the FCPA counts because the government hadn't turned over the exculpatory evidence. It's always been a major motion for me. Some people are content to just do a 3-page motion. And I try to really think what would be exculpatory? What can I make the government understand is exculpatory? And let's define it in here and don't make it ridiculously onerous because then you'll get an answer where the typical government answer to a Brady motion is we are fully aware of our obligations and will turn over material as and if we find it. That doesn't cause them to go and sit down with the agent and to see, okay, what files do we have? Who have we interviewed? Was there exculpatory evidence? If there is, let me see the memo and we're going to turn it over. And I used to have a rule with a trial partner in the U.S. Attorney's Office, which is pretty basic. If it hurt my case, turn it over. And that's what we did. But I think a lot of people sort of try to cut it down and overly analyze it and say, we really don't have to turn over that. And unless that witness calls, it's not really our exculpatory. I think those kinds of situations, and in 2 of the 6 cases, there were discovery violations. And I think what happens, to be fair to the DOJ, is these cases are massive. I mean, they produce millions of documents. And when I was prosecuting cases, I tried to boil down my case to 25 documents. I might have 200,000, but I wanted to make it simple. I'd key down, and a lot of people want to introduce 100,000 documents and all that. I just don't think that's the most effective way. But I think it's really important for the government to have a conversation with their agents, the paralegals. One of the cases in New York, they said a paralegal in Washington, D.C. was in charge of reviewing the documents. The responsibility, the buck stops at the top. And that was just another mistake. And because these cases are so voluminous, I do think there's a greater duty on the part of the government to work with their agents, their paralegals, their lawyers, and make sure we've turned it over. Because there's nothing worse for the government or the defense is having a new trial declared and starting all over. It's timely, it's untimely, it's costly, and it's not fair. So that's an area that I really drill down and always will.
Peter, let me change focus just a little bit and ask you, what are some of the key international ABC trends that you highlighted in this edition, and where maybe you see international enforcement down the road in the next 5 years or so?
I'll answer that, but can I go back to a question you asked? Because Bob's answer on trials actually jogged something in my mind. You asked before about what are the key changes really conducting and defending investigations. I would just very quickly add 2 things. One is what Bob was sort of getting at in his comments about trials and the evidence, Brady materials, et cetera, from there. But the data, I mean, conducting a cross-border investigation these days, knowing that people regularly, particularly outside the United States, are communicating, emails are antiquated. They're communicating through various private communications networks, ephemeral messaging, needing to grab that, but then also needing to comply with pretty complex data privacy, data protection regimes, and doing that all in the very early hours of the investigation as you kind of work through it to make sure it's locked down and preserved, knowing that, again, the DOJ's emphasis on prosecuting individuals, that's a real complexity and one that gets worked out in real time across borders. The other thing I would say is I would imagine that the DOJ would itself acknowledge it's become far more sophisticated in terms of how they evaluate compliance programs at companies. And I think part of the trial or presentations to the government, part of it's telling a story and a narrative to show that the company gets it, that this is a compliant company. It may have had an issue, but as you now approach that compliance presentation, the level of detail and the practical questions that the DOJ proactively asks, given their background and experiences, it can be quite voluminous and frankly quite important to the presentations. Just wanted to add those 2 points. But to your next question, Tom, on international enforcement, I kind of think of international enforcement as 4 variables. One is just the sheer level of business activity. 2 is the level of interaction with governments and SOEs and SCEs in the economy of the country. 3rd is the corruption environment of the country, and 4th is the level of cooperation with international enforcement authorities. And looking ahead on trends in enforcement, I think China will continue to be a focus. It's just it hits many of those. It's I think by the Stanford FCPA clearinghouse, they are by far the leader in terms of where FCPA cases originate. I don't think that's changing anytime soon. But it also is the global economy changes in geopolitics. I would be mindful of where businesses are moving supply chains and capital. And I think you're going to see Mexico overtook China as our largest trading partner. And I think Southeast Asia rank pretty high in my mind where you're going to start seeing. And I would also keep my eye on the Middle East. I think as those nations kind of move away from their traditional economies, carbon-based economies, to other forms of economic activity, and really doing so through government investment, spurring growth, I think you're going to see a lot of challenges, a lot of opportunities in business, but a lot of challenges from a compliance perspective.
A year,
Maybe go ahead.
a year ago, I did a study of gift, travel, and entertainment abuses, and 85% of those cases were China. And China has a long tradition of gift giving, and it's part of their culture, et cetera. I think what happens with multinational companies is they hire locals in China or in Taiwan, et cetera, and they don't train them well enough. And they say, oh, you can give them a trip to a resort for a weekend, or you can give them this. And before you know it, a major multinational company like 3M, about a year ago, is charged with an FCPA violation for gifts, travel, and entertainment. It's just, and this is going on. I don't see any decrease in these cases at all. They're not as serious as a $100,000 bribe or a government contract that's worth 5 years and $25 million. But, it starts, and if people think they can do that, then when they get promoted, they might think they can do much more serious things.
Let me ask you, as we move towards the end of this episode, ask you both to prognosticate into the future a little bit. Where do you see the evolution of FCPA enforcement literally to mid-century, which is 2030 and beyond? Bob, you want to give that a shot?
Sure. And it's funny because this is a great question that I've been asked about every 3 years, Tom. So this is the most recent iteration of it. And my answer hasn't changed, which is every time I think with all this training and all these resolutions and expensive fines, surely everybody's got religion. And then I look and I see the SAP case that just came down, SAP, that's $220 million. You've got Ericsson, which is just a nightmare involving lawyers not following through on a DPA for 3 years. And all of a sudden the company now losing its DPA and having to plead guilty and pay an additional $220 million for a $1.3 billion fine. Then you have Glencore, which paid out over $1 billion worth of bribes. And then you have Goldman Sachs. So you look at those 4 cases, like in the last 4 years, and you say, this is going to go on.
Peter?
Yeah, I think anti-corruption enforcement, there's always a prognostication that it's done and it's over, but I think it's a foundation for free and fair markets, and you're going to continue to see it. But I also see it changing a bit going forward, and particularly given the time frame you flagged, Tom. It's really becoming essentially a calling card or a brand for Western democracies. I mean, there's nothing new under the sun in a weird way. I mean, the FCPA's origins lie in scandals that were exposed that during the Cold War that made, frankly, the U.S. look like it wasn't walking the walk it talked. But I think you're going to continue to see that. You're going to continue to see the FCPA inward looking. And one thing, though, is unfortunately, the world grows to be a more tense place and a more competitive place in a negative way of that word. I would expect and hope, though, that increasingly our government and other governments that cooperate with our government, they really do get serious about targeting the demand side as well. And I think you're starting to see with these geopolitical trends more of an emphasis of not just simply looking on our side, which obviously you need to, but also looking at the demand side of global rivalry.
What's alarming to me, moreover, Tom, is when we talk about these cases, the 4 I just rattled off, it's not like they had a problem in one country. There will be 5 or 6 countries involved in that. So the culture and the regional management, or even higher, knew what was going on. I think I'd be more understanding if it just happened in one isolated country that was a new operation or an acquired business, but that's not the case. We see these cases where multinational companies are doing this in 5 or 6 countries, and I don't see great progress on the horizon. Good for the deal.
Well, gentlemen, unfortunately, we're near the end of our time for this episode. Before we leave, I have 2 questions. The first is, if our listeners wanted any more information on yourself, get the book, or connect with you guys, what might be the best way or place for them to go?
The book is available through the American Bar Association. It's the 6th edition. It's about 1,100 pages, and it really does a deep dive into these issues that we've talked about, Tim. I can best be reached at Robert W. Tarun, Tarun, @gmail.com, and my number is 312-714-0225.
Peter?
I'm quite reachable. LinkedIn seems to be quite popular to reach out these days. I'm on LinkedIn. The firm website, email peter.tomczak, Tomczak, at bakermckenzie.com. And you can always reach me on my office phone or mobile phone, 312-861-8030 or 312-804-2717.
Peter, we have a tradition here. Any U of M law grad, I get to ask one question. And that question is, I know it's a tough one, what's your favorite Hutchins Hall memory?
And you mean of something that happened in Hutchins Hall?
I'm going to limit it to that.
Or the take the 5th. Should you take the
or the quad?
I'll be the rare defendant who testifies. But no, I remember a lot of clips from a lot of very brilliant professors. One English professor used to intone always in his accent, what would Posner say? And one professor walked in the first day and said, I'm the buster of dreams, after saying his name. But I remember an incident where contracts professor and our Civ Pro professor, at the urging of one brilliant yet remain nameless law student, who I was friends with to this day, but she had proposed that they sing the ABBA song, and they both took a chance. And to their credit, they both got up, donned purple and black wigs, and actually did a pretty good, I would say, a pretty good rendition of the song, with one of them repeating "Took a Chance" in front of the whole school, in front of the whole class. So I do remember that, because it did catch us off guard that they would do something like that.
That's great. Gentlemen, I wanted to thank you again. I've wanted to do this, like I said, for a long time. And I hope an audience got as much out of this, both on an intellectual basis and, frankly, just on a fun basis. I can't wait to continue this conversation.
Thank you, Tom.
Thank you for having us, Tom.